I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I beg to report that the bill entitled Police Amendment Bill 2025 has passed through committee with amendments. Madam Speaker, I move that the bill entitled Police Amendment Bill 2025 be read a third time and passed as amended.
I second, Madam Speaker.
Honorable members, it has been moved and seconded that the bill entitled Virgin Islands Police Amendment Bill 2025 be now read a third time and passed as amended. Those in favor? Aye. Those against? The ayes have it. The motion is passed. I call upon the clerk to read the bill a third time.
This bill shall be cited as the Police Amendment Bill 2025.
The bill has been read a third time and passed with amendments. I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I move that leave be granted to introduce the following bill standing in my name shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024.
I second, Madam Speaker.
Honorable members, it has been moved and seconded that leave to introduce a bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be granted. Those in favor? Aye. Those against? The ayes have it. I call upon the Premier.
Madam Speaker, I introduce the bill standing in my name shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024. I will explain its provision at the second reading. Madam Speaker, I move that the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be read a fourth time.
I second, Madam Speaker.
Honorable members, it has been moved and seconded that the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be now read a first time. Those in favor?
Aye.
Those against? The ayes have it. I call upon the clerk to read the bill for the first time.
This bill shall be cited as the Computer Misuse and Cybercrime Amendment Bill 2024.
Thank you. I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I move that standing order number 52-2 be suspended to allow for the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 to be read a second time.
To raise my concerns with this 1 to 3 approach on bills that have significant implications on the fundamental rights and freedoms of the people of the Virgin Islands. Madam Speaker, this bill, with the implications that it has, should have been out for greater public consultation. For example, Madam Speaker, within this bill, the police can ask persons who are of interest in criminal matters to provide them with the password to their phones. And there are other things within this bill that are very troubling that must be ventilated for the understanding of the public. What we are doing in this House is wrong. I wanted to make sure that I raise my concerns on that. The Premier should not be doing this without public consultation.
Is there a second to the Premier's motion?
Madam Speaker,
Honorable members, it has been moved and seconded that standing order number 52-2 be suspended to allow the bill entitled Computer Misuse and Cybercrime Amendment Bill 2024 to be read a second time. Those in favor?
Aye.
Those against? The ayes have it. The motion is passed. I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I move that the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be read a second time, and I will now give the objects and reasons. Madam Speaker, I rise today to address a crucial matter concerning the Computer Misuse and Cybercrime Act of 2014 and its implications for our jurisdiction. In light of recent findings from the Caribbean Financial Action Task Force, this discourse is central to our legal framework and holds significant importance for our standing in the international community. The Computer Misuse and Cybercrime Act, enacted in 2014 and amended in 2019, establishes essential provisions aimed at safeguarding computer materials from unauthorized access, modification, and interference, while addressing the broader challenges posed by cybercrime. However, there are numerous gaps within this act, which has caused severe limitations on the investigatory powers of law enforcement, which in turn has undermined several predicate offense matters that were before the court. As we continually strive to bolster the security and integrity of our information systems, it is imperative that we examine and amend this legislation to align with international standards. In February 2024, the Caribbean Financial Action Task Force released its fourth round mutual evaluation report, which assessed the Virgin Islands' compliance with international standards. The report classifies our jurisdiction as compliant with 11 recommendations, compliant with 11 recommendations, largely compliant with 25 recommendations, partially compliant with 3 recommendations, and non-compliant with 1 recommendation. This comprehensive evaluation highlights areas of achievement as well as those requiring urgent attention to strengthen our anti-money laundering and combating the financing of terrorism framework. Immediate Outcome 7 of the MER reveals that amendments to the Computer Misuse and Cybercrime Act are vital to the enhancement of our current investigative and prosecutorial tools. As we draw nearer to the close of the observation period, it is imperative that we demonstrate meaningful and measurable progress on the recommended actions to avoid the jurisdiction being placed on the grey list for a protracted length of time. As it stands, the Act is limiting the scope of investigations, thus allowing criminals to take advantage of the system. The proposed amendments aim to rectify deficiencies by realigning our legal framework with international standards, improving law enforcement's effectiveness in investigating and prosecuting serious crimes, all the while striving to safeguard the individual rights. Particularly, they seek to introduce clearer definitions, broaden the scope of applicable offenses, and strengthen investigative powers for our law enforcement agencies. Without these amendments, the law enforcement agencies would not be effective in investigating and prosecuting cybercrimes and more broadly financial crimes. Furthermore, amendments will give access to necessary information during investigations and provide for the lawful seizure of computers, ensuring that evidence obtained remains admissible in court. In order to secure MLTF convictions, there must be sufficient evidence to dispel the evidential burden, and so these amendments to the Computer Misuse and Cybercrime Act would allow for modern technology such as computers and phones to be inspected for and admitted as evidence. Thus, these proposed changes are not merely legal formalities. They represent our commitment to strengthening our AML, CFT, CPF framework and to provide the international standards set out in the MER regarding law enforcement and improving our investigative procedures. By implementing the recommended actions outlined in the Caribbean Financial Action Task Force Mutual Evaluation Report, the Virgin Islands would be operative in promoting global security and preventing the abuse of our financial systems for illicit activities. In conclusion, Madam Speaker, by fortifying our legal framework, enhancing coordination among domestic and international agencies, and augmenting the capabilities of our law enforcement agencies, we are taking cogent steps to prevent and combat cybercrime and financial offenses. Together, let us demonstrate our unwavering commitment to transparency, accountability, and a secure financial landscape for these Virgin Islands. Thank you, Madam Speaker.
Is there a second?
Madam Speaker, I raise a second, and at the same time, before I sit back, give my contribution to the bill before us. Madam Speaker, we have just spent the better part of 2 days working on the bill for the police bill. And it was much longer than this one, and I think probably more contentious. All members, Madam Speaker, have worked in harmony to make whatever amendments were necessary. And I think that we came out satisfied that the government was amenable to the recommendations, the wishes of every member in the House. I don't think that anyone's request was denied unreasonably or denied, period. And I see no reason that this bill should be any different, Madam Speaker. When I first started looking at these two bills, this is the one that caught my eye and garnered most of my attention. Madam Speaker, this bill in Section 2 amended, it says the Computer Misuse and Cybercrime Act Number 9 of 2014, hereinafter referred to as the Principal Act, is amended in Section 2. In subsection 1, in the definition of the word computer, by inserting after the word the internet the words digital video recorder, DVR, closed circuit television, CCTV, cellular phone, and the like. Madam Speaker, my first question on this one is, we ought to say what we mean, Madam Speaker. We should not be stretching, expanding the meaning of a word to the point where it's meaningless when it comes to a computer. Madam Speaker, all the things that are listed here, when it says, in the definition of the word computer, by inserting after the word internet, the word digital video recorder, DVR, I don't believe, Madam Speaker, these things should be defined as computers. In other words, it seems to me, Madam Speaker, is that somewhere along the line there's a reference to a computer, and it's picking up all these different things. I think that we should list each item and give them their own relevance to the Act. It can be the same as was done for computer. We should not allow anyone to categorize cell phones as a computer. And besides, not all cell phones are computers. It lists the court, Madam Speaker, to mean any court of the territory of competent jurisdiction. I'm sure that you will find somewhere where that meaning is different. Harmful content, Madam Speaker. Harmful content is defined as any content that constitutes child abuse material, in accordance with Section 14, or B, being capable of causing harm or otherwise being illegal to possess within the Virgin Islands. What about besmirching a person's integrity or any individual, Madam Speaker? Shouldn't that be considered harmful content as well? We have situations where online news, bloggers, they get up and they say anything they wish about an individual, even going as far as mentioning the names. Isn't that harmful, Madam Speaker? I think the definition of harmful content should go in as far as to talking about besmirching an individual, or in this case, libel, Madam Speaker. Police officer means, it says, a constable or any other officer holding a higher rank of the Royal Virgin Islands Police Force, or B, any other law enforcement officer of any other jurisdiction authorized in writing by the Commissioner of Police to carry out or assist with an investigation on behalf of the Royal Virgin Islands Police Force. Question I have, Madam Speaker, is what is a law enforcement officer? This individual doesn't necessarily have to be on the Royal Virgin Islands Police Force, considered a law enforcement officer. Protected information means any electronic data which, without the electronic key to the data. Protected information means any electronic data which, without the electronic key to the data, A, cannot or cannot readily be accessed, or B, cannot or cannot readily be put into an intelligible form. What's the relevance of that, Madam Speaker? To point out to me protected data. 2A, Madam Speaker, B2A. For the purposes of the definition of harmful content, content is capable of causing harm where it, A, has a material risk of significant adverse physical or psychological impact on a person, or B, is considered to be obscene, offensive, or in violation of public decency as assessed by the standards of an ordinary, reasonable person. Again, Madam Speaker, I go back to what about information that besmirch an individual. These things should not be allowed to go unchecked. If we're going to talk about cybercrime, Madam Speaker, we need to put these things in that same category. I was, at one time, Madam Speaker, at wit's end with that type of behavior, content that besmirch me in particular. And I asked a trusted source, Madam Speaker, I said to them, you know, I've gotten to the point now where I think something has to be done. And I'm going to do something. And I was told that as a public official, I should expect myself to be held at a higher standard, and therefore I should leave it alone. But Madam Speaker, as far as I am concerned, that was back then, several years ago. And this is today. And I think that too many people are being harmed by those who are so careless as to do so. Recklessness. And we have to address that in this legislation, this piece of legislation, as well as we intend to address other things. Section 14I amended, Madam Speaker. Section 14I of the Principal Act is amended by inserting after the words an offense, the words under this act or any other enactment or common law, Madam Speaker. Madam Speaker, I ask a question, what is common law? This terminology keeps showing up, Madam Speaker. And none of us, the people who are responsible for making the law, knows what it is. For us to sanction it is irresponsible. If there's something that is desirous about being legislated, someone ought to tell us, spell it out. And if we find that it's necessary to include it in the legislation, I see no reason why we shouldn't. But this be all and catch all term common law, I have a difficulty with it, Madam Speaker. Section 14J, it shows up in 14J, 4A2, it says, by inserting after the words an offense, the words under this act or any other act, enactment, or at common law. Again, shows up, Madam Speaker. Shows up again in section 14L, amended 5A. And it says, section 14L of the Principal Act is amended A in subsection 1 by deleting the words investigation or the prosecution of an offense and substituting the words a criminal investigation for or the prosecution of any offense under this act or any other enactment or at common law. What am I supposed to make of that? I don't know what it means, Madam Speaker. I just read that little section. I don't know I don't understand it. Tell me what you want me to put in there. Tell me what we need to put in, and we can put it in. Section 14L amended 5B CA in subsection 2 by inserting after paragraph C the following paragraph CA require a person in possession of an electronic key to provide access to such protective information as necessary for the purpose of investigating the offense. The fact that data is protected, Madam Speaker, does not necessarily mean that I think I'll leave that one alone, Madam Speaker. It's a little difficult. Section 14L-A and 14L-B is inserted. The Principal Act is amended by inserting after Section 14L the following sections. Powers of access, search, and seizure for the purposes of investigation under another enactment. It says 14LA1, a police officer who is lawfully on premises through the authority of a court under another enactment may, if the police officer has reason to believe that stored data would be relevant for the purposes of any criminal investigation or any criminal prosecution, seize the computer. 2, Madam Speaker, a police officer in lawful possession of a computer. Madam Speaker, I am not someone who is going to stand here and say that police officers should not have all the tools available and at their disposal in order to gather evidence so that if an individual has committed an offense, that they should not have the evidence that they need in order to convict that person. But what I'm saying, Madam Speaker, if the procedures are clear, if the procedures are clear under which that evidence is to be gathered, and a police officer fails to execute in accordance with those guidelines, there should be no indemnity on that individual. That evidence should be done away with, and we should not be legislating ways and means for, for them to be exonerated for what they've done. So that's my position on this, Madam Speaker. Admissibility of data previously obtained, notwithstanding any other provisions of this Act. Data that has been lawfully obtained prior to the commencement of this Act pursuant to a warrant issued under Section 14L or any other enactment shall be admissible in any criminal proceedings under this Act or any other enactment. I think they're saying something here, Madam Speaker, that they're not saying. We need to know exactly what it means, what that particular statement means. And in the committee stage, the questions will be asked, and I hope that we can get those answers. They're readily available, and we'll get them, Madam Speaker. Section 14T and 14U inserted. This is Article 9. The Principal Act is amended by inserting after Section 14S the following sections. Authorization to provide technical assistance. 14T. The Commissioner of Police may authorize in writing any person from within or outside the jurisdiction to provide technical assistance as may be necessary for the purposes of investigating a criminal offense. Madam Speaker, this should be done based on regulations, and any such regulations must come back to this Honorable House for positive resolution, Madam Speaker. I have absolutely no problem with the wording as to how the Commissioner of Police may authorize in writing another person to do this work. But, Madam Speaker, I have a difficulty with the Commissioner of Police reaching across the waters into an international territory. So if he's going outside of the territory, Madam Speaker, I think that he should get the clearance. I should be in consultation with the governor. 2, the Commissioner of Police shall keep and maintain an updated record of all persons authorized to assist in the investigation of a criminal offense. I would presume, Madam Speaker, that that is something that was natural and that's being done as we speak, as I speak. Interpretation of this division. Interpretation of this division, 14U. A reference to any other enactment under Section 14A to 14T is a reference to every enactment in the Virgin Islands, whether passed or made before or after the commencement of this Act. Madam Speaker, that's a section that I need clarity on. I think that it behoves every member of this House to get clarity on it. And I'm sure that many of us have positions on that. I will leave it there. And Madam Speaker, that's the extent of my contribution to this bill, Madam Speaker. Thank you.
Thank you, honorable members. The floor is now open for debate. Any member wish to debate at this time?
Madam, I am a point of privilege to ask that we come back on Monday or Tuesday to deal with this very important bill, computer misuse and bill, and cybercrime bill. Honestly, it's important for us to do what's good and right. You heard the member for the third, the deputy premier, the extensive things that he read out. It needs us to address our minds to all of this stuff so we can inform the public in a much more educated way. So I will ask that, Madam Speaker, that the premier consider we come back tomorrow, Monday, Tuesday, and let's address our minds to this bill.
Premier?
Madam Chair, sorry, Madam Speaker, tomorrow is the opening of the law year.
Yeah, you could come back in the afternoon.
Madam Chair, I'm willing to delay whatever is on my schedule. The House is the first call on members to come back tomorrow. I'm not sure if we have any logistical concerns, whether we'll have witnesses and counsel available on tomorrow. And that's why I wanted to endeavor to get it done tonight, because I know we have some logistical challenges.
So if I may, if we are to delay, then I would suggest it be either next Monday or Tuesday, given the availability of counsel who deals with who dealt with this particular legislation.
Yes, Madam Speaker, I do understand. We have done the things that we are supposed to do. We're letting people, the authorities know that we are serious about this bill. It's being introduced, and the Premier and the Deputy have laid out the provisions in the bill. So coming back here Monday and doing it, let's do it. Let's do it.
Madam Speaker, I know that some of these matters as well are time sensitive as well. I really wanted to have this bill passed since last year. We are here now, and delay will have implications. So, Madam Chair, my strong preference is for us to go through now, but Madam Speaker, I'm only one person. I'm only one person, and members will have to decide whether they'll stay or not.
All right, let's just take a brief recess, all right? Take a brief recess. This House now resumes its sitting. All right. Given that we haven't arrived at a consensus, I'll just say, members, the floor is still open for debate. The floor is still open for debate.
Okay, Madam Chair.
If no member wish to debate, then I'll have to call on the Premier to wrap up. Yes, I recognize the member for the 6th District, Honorable Myron Walwin.
Thank you very much, Madam Speaker. Madam Speaker, I rose on my feet earlier to echo my concerns with the way in which things are being done in this House. Madam Speaker, we practice a Westminster system of government, and part of that parliamentary democracy we have makes allowances for the involvement of the public and consultation with the public. And part of the manner and form of legislation is you have first, second, and third reading, the break between the first and the second reading to allow for public consultation, so that people can see what is happening in the House. They can reach out to their respective representatives and say to them, I've noticed a particular bill that I'm concerned about, and I want you, when you go to the House of Assembly, to show that you are not in support of it for X, Y, Z reasons. In this sitting, Madam Speaker, on very important bills, and I'm sure, Madam Speaker, even though you're the Speaker of the House, I am sure, you could correct me if I'm wrong, just don't do it publicly, do it privately, that people contacted you as well about that police bill. All of us in here got calls from our constituents or other people about the things in that police bill that were of concern to them. Never mind, we took the time and we went through the bill. We did some research. The anxiety that things create in the minds of the public is not good, particularly since, and we have to make some changes in the way we do legislation and deal with legislation in the House. We'd have just gone through the police bill, first, second, third reading, and then the public doesn't see the final bill. They're still wondering what it is really actually happened, because all they would have seen would have been the first draft, which would have been alarming. They wouldn't have seen the final draft to help to allay their concerns, and we can't do this to the public. And here we are now again with this bill, all because we're trying to meet a deadline to please some people and doing harm or detriment to the public who sent us here, Madam Speaker, to represent their interests. I am reluctantly debating the bill, reluctantly. only out of love for the people and concern for the people, because I know if you don't raise your voice in here, the government who hardly reads the bill will go and do something, again, that will affect the life of our people. That's the only reason why I'm here. That's the only reason why I'm here, because the people of District 6 sent me here. And I want to make sure that no laws are passed that I know would affect them. And I looked through the bill. I took a little time to look through it, notwithstanding the fact we didn't have as much time as we should. And, Madam Speaker, I looked firstly at the interpretation. And I see where it says a criminal offense means any criminal offense at common law, A, or B, which is recognized and enacted in statute within the legislation of the Virgin Islands. And Madam Speaker, I'm concerned about the use of this term common law. And it is something that should not be encouraged. As a matter of fact, the United Kingdom is moving away from that. Offenses, particularly of a criminal nature, must be precisely defined by statute. We cannot do this. And I'm going to show you how the bill, through and through, is riddled with problems. You cannot have utilize the term at common law to mean any criminal offense. That is wrong. You are offending the principle of certainty in law, and there must be certainty in law. And so when you do this, you are creating issues. What I've noticed, Madam Speaker, that we are trying to do in this House, which is wrong, and I want to make it lucidly clear, because sometimes when you speak, people give the impression as if you are against what is good and right for the country. No. No. We do not want criminal elements in our society. We do not want them. We want anybody who is committing criminal offenses to be treated with the fullest extent of the law. But the law must be fair. The law must be fair. There's an old legal maxim that says, he who comes to equity must come with clean hands. You can't do wrong things to fix wrong things, because it makes you no better than the wrong that you're trying to fix. And so through and throughout this bill, Madam Speaker, I will show you very strongly where my concerns are. And I've always been ridiculing this government about reading the bills before they come to the House with them. They're not reading the stuff. They're not sitting down, and they're not understanding the implications of the things that they're bringing to the House. And then you want to rush them 1, 2, 3. The leader of the opposition said, let us come back. Let us come back. And he's saying so in the context that give us a break in between, so that we can consult with people about the things that are in the bill. And that was denied today. 1, 2, 3, to serve the interest of somebody else, except the interest of the people who sent us here. Now, in the team, in the interpretation, there's the electronic key, and it says, in relation to any electronic data, means any key, code, password, algorithm, or other data, the use of which, with or without keys. I want you to bear that in mind, because I want to come back to it to show you, Madam Speaker, my concern. So stick a pin there, as my grandmother would say. We go to section 14J. Section 14J says, well, section 14J amended. Section 14J of the Principal Act is amended A in subsection 1, by one, renumbering it as section 14J, and two, by inserting after the words "an offense" the words "under this act" or any other enactment at common law. This is used through and throughout the document, Madam Speaker. Any other enactment or at common law. I'm going to show you that this is wrong. Section 14L as amended. It says, Section 14L of the Principal Act is amended A, in subsection 1, by deleting the words investigation or the criminal or the prosecution of an offense and substituting the words a criminal investigation for or the prosecution of any offense under this act or any other enactment or at common law. There it is again. Madam Speaker, and you would know this. Any offense, an offense is created under a specific act. An offense is created under a specific act. When you are laying an indictment, when you're laying a complaint, you have to reference the specific act that the person has offended or has caused to be offended and would be the purpose for whatever is happening to them, whether it's an indictment, whether it's a warrant, whatever it is. You cannot transport, Madam Speaker, that act into other statutes at law. It's unlawful. It's unlawful. And it cannot be used to issue warrants for offenses that the act did not create, which is what this is doing. You cannot say "and any other enactment or a common law." You can't do that. That is wrong. It's unlawful. Any judge will tell you that. You can't do that. And this House cannot give permission for that. And then it goes on to say B in subsection, and I'll show you something. Let me read. I'm going to read something for you, because if you believe I'm making up Nancy's story, I'm going to read for you. I'm going to read for you. I am reading, Madam Speaker, from a case from the High Court. Michael Robin is the applicant, and the Director of Public Prosecutions, the first respondent, and the AG Chamber, the second respondent. And this is what the High Court judge had to say in relation to the point that I've just raised about any other enactment at common law. At 11.4 of the act, of the judgment, the judge says, under a proper reading of this act as amended, it is clear, because the case surrounds this, and the House of Assembly has got to learn to do its investigation to understand what it is you're being brought here to do. This act is not about no cybercrime and no mutual evaluation. It is not. It is false. It is false. And I'm going to show you it's false. It is to correct the errors in this case. It has nothing to do with a mutual evaluation. Absolutely nothing. And the Premier got up reading that foolishness without even checking to see that he's being hoodwinked. I will read it to you. I will read it to you. This is what the court had to say. Under a proper reading of this act as amended, it is clear that Section 14L confers power in relation to investigations of offenses created by that act. They're speaking about 14L, the Principal Cybercrime Act. And that section cannot be transported out of the act into any other statute. In other words, this section cannot be used as the basis for issuing a warrant in respect of offenses not created by the Act, for the Act does not expressly or by necessary implication permit that to be done. You understand what I'm saying, Madam Speaker? I put it to you today. So what is being done here now is any other enactment at common law is being used to plug what the judge said you're not supposed to be doing. That is what is happening here. That is what is happening here. And you are coming full speed ahead, not paying attention to anything and rushing the things them through, and they're going to be unlawful. I'll show you more. Look at B. In subsection 2, by inserting paragraph C, the following paragraph: require a person in possession of an electronic key to provide access to such protective information as necessary for the purpose of investigating the offense. You see that word I told you about, electronic key? You know what electronic key means? I'll read it now. In relation to any electronic data means any key, code, password, algorithm, or other data, the use of which with or without keys. So what this section is doing now is saying that if the police come in your house, and I'll show you further down, and they're supposed to have a warrant, let's say you commit a firearm offense. The warrant will tell you what the offense is and so on. And because you can't carry it to the magistrate or the judge. You go in and you're supposed to look for things that in relation to the firearm thing. You ain't gonna call, go in my fridge, go take out nothing. Go in my bed, take out my shoes. No. You're supposed to go in for things that are in relation to the offense. You go on in there, you see my cell phone. My cell phone has a lock on it. Yes? It's private. What you are authorizing here now is giving the police power to tell somebody that they must give you the password for their phone. That is what you are proving here. And I'll show you how it's wrong. If you go to the Constitution of the country, 15.3 of the Constitution. It says at 1, every person has a right to liberty and security of person. 3 says, any person who is arrested or detained shall be informed promptly as prescribed by law in a language that he or she understands of the reason for his or her arrest or detention or his or her right to remain silent. You have a right to remain silent. That extends to your pass key, word, your information on your phone. And we are in this house giving permission to the police to breach section 15.3 of the Constitution of the country. When people warn you and say, leave certain things alone, let them breathe out. You must let them breathe out. I will show you further. Go to section 23 of the Constitution. Freedom of expression. No person shall be hindered in the enjoyment of his or her freedom of expression. 2 says, a person's freedom of expression includes freedom to hold opinions without interference, freedom to receive information and ideas without interference, freedom to disseminate information and ideas without interference, and freedom from interference with his or her correspondence or other means of communication. That's 23. Now, again, you go to the case of Michael Robin. This is what I do for a living. This is my job. So when the bill them come in here, you suppose you see me burning the midnight oil, digging and I find the thing them. Let me show you now why this section is here. You go to the judgment, page 20, 11.14. This is what the judge says on the right to silence on this very point. For the avoidance of doubt, if, as stated in Green is a case that the judge referenced, where the Honorable Justice Tom said, it is settled law that a person has the right to silence. The right is protected as a fundamental right in the Constitution of the Virgin Islands. A person cannot be compelled to produce evidence which may have the potential to incriminate him. It follows that any section which criminalizes the exercise of that right, in the case, the refusal to provide a PIN, which is the purpose why you're here with this bill again, must contravene the applicant's right to remain silent, guaranteed by the Constitution. And that section must therefore be unconstitutional, null, void, and of no effect. So this house is coming here now. The judge tell you that what you are doing here is unconstitutional. And here is this House of Assembly being hoodwinked to come now to undo what the judge said. When you go back and you fix that, it will still be unconstitutional because you cannot make a law that is inconsistent with the Constitution of the country. AJ, you can get up in there. If you're talking foolishness, you have the right to get up. Just like the right to silence exists, the right to speak exists in the House. If I'm talking foolishness, tell me you're talking foolishness. We have got to pay, Madam Speaker, a lot went into this country to get it to where it is. The BVI ain't built just so. You could call me all the island man you want. I see things happening here in this country where I am from. And a lot of sweat and tears went into getting this country to where it's at. And you people, some of our people on the government side, not paying attention, squandering the things that we fought for. You're playing with the fundamental rights of our people and you're rushing bills through the House that have legal implications that will get struck down when it goes to court because you're not paying attention. Then you go to sections 14LA and 14LB. Powers of access, search and seizure for the purpose of investigation under another enactment. 14LA, a police officer who is lawfully on premises through the authority of a court under another enactment. Another enactment? Hey, come in there again. Right? If the police officer has reason to believe that stored data would be relevant for the purpose of any criminal investigation or any criminal prosecution, seize the computer. So now, you say, what offense I should use, Madam Speaker? You say a thief. I went in somebody's house and a thief, the thing them and I carry them home. And you want a warrant to come search my house to see the thing where you see a thief in my house. The person say, I am missing X, Y, and Z. You come with a warrant because you see a thief. You're looking for X, Y, and Z. How you end up with my phone? How you end up with my computer? That don't have nothing to do with what is on the warrant. Yes, when you're exercising the warrant, yes, You can seize things that are incidental to the warrant, but you are not to go out certain parameters. So what we are being asked to do here is that if the police say they come in your house because you thief couple items where they know you thief, once they're in there and them see a computer, they could grab that one time. That is what we've been asked to do. That is what we want to happen to our people. You all understand this is what this section is saying? And then it goes on to say, a police officer in the lawful possession of the computer under subsection 1 may apply for a warrant under section 14.1 to access and examine the data stored on the computer and to exercise it. So you come in to thief for some items that you say a thief X, Y, and Z. You come in my house, you pick up A, B, and C, and now you are give the police officer, and A, B, and C is my computer, my phone, now my business. You are now giving the police officer the authority now to go look in my phone that has nothing to do with what a thief. You're fishing. You're on a fishing expedition. That is what you are on. And Madam Speaker, if you don't believe me, I will show you. I will show you the case of Michael Robin, and I will show you what the judge had to say on this very thing. And it's in relation to this very, very area that we are amending in this law. This is what the judge had to say. They me saying it, the judge. Apparently this case had to do with the police going in, say they want to go for one thing and then take up things that they may have called techno. I love the police. I'm an advocate for the police. The police will tell you that. I do some batting for the police inside here that people ain't do yet. I remember one Saturday, we were doing something when the police officers were being sent home at an early age. You remember, Honorable Fraser? I called you a Saturday morning walking from a funeral. I said, Fraser, we have to work with the police and try to get this age change. And it's because of the efforts of you and I together, is why the police has the age limits increased. So I like the police, and I expect them to protect me and protect the citizens of the country. But I like fairness too. The right things must be done, Madam Speaker. And the police, what we need to focus on more is training the police, do professional development, show them how to do things the right way. That is where the effort should be, not bending the law when the things are done wrong. And when they do it wrong again, you're going to come back again and bend it and bend it and bend it and bend it. And every time you bend, you're encroaching on the fundamental rights and freedoms of the public. And this house, 1, 2, 3, whoops, whoops, whoops. And everybody's saying, don't do it. I love the Premier, but he don't listen. I don't know who it is troubling him. It looked like somebody got a whip on his back. I don't know I don't know what it is. I don't know what it is. But it is something, and I pray whatever it is, you get it out for you. Now, the judge says at 10.2, Madam Speaker, in relation to this same seizure, hear what the judge says. Apart from the items at 1, which the police could legitimately seize under warrant 1, because of their suspicion that there could be prohibited drugs, cannabis, none of the other items seized were remotely related to firearms or ammunition, and none were illegal items per se. So they went in looking for things in relation to firearms and something else. Yeah, you follow me? They pick up dog, cat, rat, donkey, everything they find in the people's house that have nothing to do with the warrant that was issued. And then the judge went on, the police were not allowed to throw fly to catch bait. That's what the judge said. The warrant did not authorize the seizure of those items, and the police went beyond the express and implied terms of the warrant and seized the items belonging to the applicant. There was no incidental basis to seize those items. What you are being asked now is are you go in your house and regardless of what I see in there, whatever the offense is on the warrant, I can go to your computer, pick up your business and go with it. This is what the court went on to say. And this is a case of Queen versus St. Elmo Garraway. The judgment of that case says, let us assume, however, that the search warrant was properly obtained by the police for its stated purpose. Did the warrant allow the police to seize the video equipment and download the video recordings? This is another case where the police went in for something else and they do something else and they're gonna call doing. Certainly those items were not enumerated in the search warrant. The warrant was granted in relation to firearms and ammunition. It is generally accepted that the police can go outside the named items in a search warrant, but there are parameters to that. The material must be relevant to the investigation. This is the court. So how can you go into my house for any offense and then go seize my computer? My computer might be totally unrelated to the offense. And this house is being asked now to allow them to do that, and then not allow you to only get the thing you're supposed to get, but to turn around and give you permission now to search the thing where you're not supposed to have in your possession in the first place. Madam Speaker, that can't be right. And then you go down to admissibility of data previously obtained. Notwithstanding any provision of this Act, data that has been lawfully obtained prior to the commencement of this Act, pursuant to a warrant issued under Section 14L, or any other enactment, shall be admissible in criminal proceedings under this Act, or any other enactment. You understand this, Madam Speaker? Premier, you understand what you bring here? Premier, I'm talking to you, man. You understand what they give you to bring here? I'm going to read it again. Notwithstanding any other provision in this Act, data that has been lawfully obtained, prior to the commencement of this Act, pursuant to a warrant issued under 14L or any other enactment, should be admissible in criminal proceeding. So you want to fix up the Act so you could go back and use it for something that happened since the devil was a boy. That is not right. That is not right. If somebody is charged with an offense, they have to be held accountable based on the law that was material at the time when the offense took place. You can't be doing this kind of stuff. This can't be what it is we want to do. This can't be what we want to do, Madam Speaker. This cannot be what we want to do. The authorization for technical assistance, being on a problem with that. The police should be allowed to be able to get, and I take the point that the Deputy Premier said, perhaps we need regulations or some sort of guidelines for what you're doing. But I have no issues with them getting technical assistance. They can summon the assistance if the assistance does not exist in the force. But what we are being asked here to do, Madam Speaker, is an absolute travesty of law. We are being asked to disobey the High Court. The High Court made a judgment and a ruling, and we are being asked now to come back in here and disregard what the High Court said. It's a country of laws. It's the country of laws. If the High Court says something is unlawful, yes, we have separate branches of government, but we have to respect the court. We have to respect the court. Especially trying to do things that we know to be unconstitutional. We could write anything we want in these laws. Anything we want in them. If they're inconsistent with the Constitution, they will be shut down. And a lot of these things in here are inconsistent with the Constitution. Particularly people's right to silence and freedom of expression. And so, Madam Speaker, in closing, and I want people to get up, Madam Speaker, I want a debate. I want somebody to get up and tell me, Myron, when you get up here and you don't know what you're saying. I want somebody to do that to me. Don't come with nothing but, no emotional thing. No. I know people got shot, and I know for sure, yes, that I want the people who shot anybody in here to get caught. People who are doing wrong things, I want them to get caught. So, Premier, challenging you tonight. Don't come with an emotional argument. You like to write down things and wrap up? I say what I said tonight on the law. When you get up to wrap up, you come and talk. Come and tell me what I say here as a matter of law that I don't know what I say. I challenge you tonight to do that. Because you'll be thoroughly embarrassed. This law here needs major, major surgery. We can't pass this kind of stuff. This House of Assembly cannot be seen to be disobeying the High Court of the country when the court has already given its judgments. You can't take wrong to fix wrong. You take right to fix wrong. Thank you, Madam Speaker.
Thank you. Any other member wish to debate at this time? Well, members, again, as I said, the floor is open for debate.
Should I leave that thing alone? I wouldn't listen.
I recognize the territorial at-large member, Honorable Donna Smith.
Madam Speaker, thank you very much. Madam Speaker, I also rise reluctantly to speak on this bill before us. And I say reluctantly because the night is far spent and we need the time to debate, to properly debate this very important bill. We have asked for more time, and since that is not forthcoming, we will at least have to proceed with the debate. I fully support the point made by my colleague from the 6th that people need the time to understand, to ventilate, to do whatever is necessary to understand these very important pieces of legislation. The Police Amendment Bill, which is now the Police Amendment Act, we were able to get through. And now this cybercrime bill is another one that needs, computer misuse and cybercrime bill is another one that needs the time to be properly ventilated. Madam Speaker, I rise in support of this bill because it strengthens our position, as the Premier said, in relation to the mutual evaluation report. Madam Speaker, the report that we received last year was much less than favorable. It is a report that immediately we committed to fixing the day it came out. We published our National Action Plan, and I believe, in fact, I know that the amendment to the Police Act, and with that also the Computer Misuse and Cybercrime Amendment Bill, is a part of what we have to fix. But I do agree with my colleague that we need the time to do so. I want to commend, Madam Speaker, the team that was here during the committee stage. I want to congratulate them and to thank them for their guidance, for their support, and for them working with this House to produce an amendment to the Police Act that I believe the country will be pleased with. there was plenty of apprehension in relation to that amendment, in relation to that bill, but I believe that together with the technical people from the Attorney General's office, as well as the police, the Royal Virgin Islands Police Force, that we've come up with a bill or an act that we can be all very pleased with. And I want to take this opportunity, Madam Speaker, because during the last debate, I made the point in relation to the police force, and I was using a report. In fact, I used the report that we are still awaiting the second volume of, that was less than complimentary about the police in some respects. I want to make it clear, Madam Speaker, that I have the greatest respect for our police force and their capabilities. We have very fine men and women on our police force, and certainly the officer that was here assisting us as an acting superintendent is an excellent example of the kind of men and women we have on our police force. I have no doubt, Madam Speaker, that, and I hope that the committee stage will come at another point, maybe tomorrow or next week. I have no doubt, Madam Speaker, that we will end up with a piece of legislation, an amendment that we will be pleased with. My colleague from the 6th, I want to also say, before I speak to one or two of the points that were made and that he made very eloquently, I want to also say, Madam Speaker, that the world, in relation to the mutual evaluation report, the world is not just looking at us, it's not just observing us. The world is drawing their own conclusions. In fact, ahead of whether we get on a gray list or a black list, they may very well make their own determination. So we must be seen to be moving with alacrity. We must be seen to be moving with purpose in terms of doing what needs to be done in relation to this bill, the Computer Misuse and the Cybercrime Amendment Bill. Now, a couple of points, a couple of specifics in relation to Section 2, the Computer Misuse and Cybercrime Act is amended in Section 2, in subsection 1, in the definition of the word computer by inserting after the words the internet, the words digital video recorder, closed circuit television, cellular phone, and by inserting in their proper alphabetical order, etc. The point I wanted to make in relation to the cellular phone, yes, we have to be concerned about cellular phones, but we know on the other hand that cellular phones can be as good or better than computers. But Madam Speaker, I am sure that when it comes to the committee stage, we will get it right. Madam Speaker, the member for the 6th spoke at length about the whole area of common law. And this was indeed a weakness that was identified in the mutual evaluation report. And if I may be permitted, I'll read a small section. It says that, again, as I said before, in terms of the areas, some of the areas, they were mostly met, but we were lacking, and I hope that we will be able to meet the gap, close the gap as soon as possible. But there's a section that reads, Authorities indicated to the assessment team, this was the team that came last year to do the evaluation, or the year before, 2023, that the common law allows for such operations and submitted a court ruling from the High Court, which admitted as evidence an audio recording made covertly by law enforcement in a murder case. However, there lacks, and this is the important point I want to make, there lacks an appropriate implementing legal framework in the Virgin Islands, as was pointed out by the judge in his ruling. The need for an implementing mechanism is further supported by legislation that, as far as they understood, was being drafted to provide such a legal framework. So it is important, Madam Speaker, that we not just rely on common law, but that we have a proper implementing framework and that we are relying on case law. Now, I don't need to spend too much time on the point made by my colleague from the 6th District in relation to people coming into the police, a police officer coming into your house for one thing and taking something completely different. These are the reasons, this is an example and one of the reasons why we need time to really look at what is proposed and time to fix what is there. He's absolutely right, because the section says a police officer who is lawfully on premises through the authority of a court order under another enactment, may, if the police officer has reason to believe that stored data would be relevant for the purpose of any criminal investigation or any criminal prosecution, seize the computer. And then section 2 says, a police officer in lawful possession of the computer under subsection 1 may apply for a warrant under section 14L1 to access and examine the data stored on the computer and to exercise such other powers specified under section 14L2. So, Madam Speaker, we all understand and we all welcome the fact that in 2007 we got a constitution that had a whole section on human rights, and we respect those human rights. We live by those human rights, and we have to make sure, as I said before, that we balance the rights of our people with making sure that there is not excessive force. And so, as I said before, we need time to make sure that we get this piece of legislation right. I do welcome, Madam Speaker, section 14Q, which says that indecent data order, section 14Q is amended, by deleting the words indecent data order, that the indecent data and substituting the words harmful content under order that the harmful content, let me read that again. Section 14Q is amended by deleting the words indecent order that the indecent data and substituting the words harmful content order that the harmful content. And then in the objects and reasons it explains that the principal act is amended to replace references to indecent data with references to harmful content. This provision seeks to modernize the language of the Act and broaden its application to include content that is not only indecent, but also harmful or illegal. So, Madam Speaker, there are some good things that this computer misuse bill, amendment bill will do. But as I said before, we must take our time to go through it and make sure that we get it right. The Deputy Premier made reference to Section 14T, authorization to provide technical assistance. I also welcome technical assistance when it is needed, and I agree with him that where we need the advice, where we need the regulations, that they be done properly and that there be an affirmative piece of affirmative order in the House made. Madam Speaker, with those few comments, I would like to thank you for allowing me to join the debate. And as I said before, I hope and I pray that there is time for a proper debate and a proper study of this bill that would give us the kind of balance between making sure that the rights of the people of this territory are not trodden on, and that the rights of, well, there's a balance between the rights of our people and the rights of, and making sure that crime is dealt with as it should be appropriately. Thank you, Madam Speaker.
Thank you, Honorable. Any other member? If not, I'll ask the Premier to wrap up.
Madam Speaker, let me firstly say we went through the police amendment bill 2025. During the debate, of course, we had some, of course, contributions which raised challenges and issues with the bill. All of those challenges and issues raised, I thought they had a legitimately raised. We went into the committee and we made very constructively a number of amendments. I believe that police amendment bill is in much better condition based on the changes which we made in committee.
All right. So, Premier, it has been brought to my attention. There are one or two things I can do.
Madam Chair, perhaps with your leave, we can call a recess and I can continue my wrap up.
Thank you.
Yeah.
All right. that date. All right, members. So members will recess to Monday, the 13th day of January, 2025 at 10 a.m.